Teams off onto silent as they interfere with the recording equipment. Apologies, and Raymond has apologised he won't be able to make it today. Any other apologies? Okay. Agenda item 2 then, draft minutes of the meeting from the 4th of February, pages 3 to 10 of your packs. If you want to quickly glance over those and indicate if you're happy enough for me to sign off the minutes.
Yeah.
Everyone happy enough? Thank you very much. Okay then, matters arising. A few to get through. First of all is a copy of the entry in the Register of Members' Interests for our new member Alex Atwood. That's at page 10 of the table pack, just as standard practice for new members. Item 2 then, just feedback from the Glasgow Drug Court visit last week. Papers relating to the visit that are available in the committee office. If anybody wants to have a look through them, we'll make those available to people in the future as well. The draft report on Just Innovation work is being prepared for consideration and approval at the meeting on the 3rd of March. And the title of the report is going to be Justice in the 21st Century, and we'll have an opportunity then to table a motion in the Assembly and have a debate around that. What we might do in advance of that is maybe pick different themes of some of the innovation work that we've done over the last year so that we cover all of the areas. But I think it's useful just to highlight the work we've been doing and maybe help to push the programme for Government and the Justice Department in the right direction for the next mandate on that. But we'll get the draft wording of that pretty quickly. I don't know if sorry, Alan, yeah?
I just wanted to comment on that. I mean, congratulations to yourself for, I think, giving leadership to the committee in relation to this approach in terms of innovation. And the visit to Glasgow was particularly helpful. It was very, very constructive. We had a very, very good engagement with Sheriff Wood, who runs at least one of the drugs courts in Glasgow, and we were able to observe the court in action, both prior to the court and also during the court, and also afterwards with a special session with Sheriff Wood. And I was very, very impressed, I must say, with the work that they're doing. I think that we can learn an awful lot from the court and the work that they're doing, and in particular the way that they have a backup team, nurses, doctors, social workers, probation people, everybody involved in this process, and it really is quite inspirational. So I think it was a very, very worthwhile visit.
Yeah, I mean that collaborative approach is really, really positive there. And just for members who weren't there, and Danny might want to make a comment. So effectively, what happens in the morning? The judge meets with the probation officers and the medical staff, and will review the cases of the people who are appearing in front of them that afternoon to determine, how their drug testing is going. So they have to do the regular drugs test, much the same as in New York. Now, a slightly different approach between the New York and the Scotland or the Glasgow system seem to be they're not seeking perfection in Glasgow. They understand that if you have addiction issues, that you're not going to come straight off drugs, after your first court appearance. But what they're looking for is, number one, that you're not offending during that period of time. And as long as you're not offending, you're still given an opportunity to complete your mandated health course. But what they're looking for is progress to be made, and whether you've got the right mental attitude to turn up on time, to turn up to your testing, turn up to your community service sentencing. But it had positive results, and the evidence speaks for itself. And there were plenty of similarities between the approach in New York and the approach in Glasgow. And there were some differences as well in terms of how the court felt in terms of the atmosphere in it. But the approach is exactly the same, and it's useful to see how it works in in America. You have a privatised health system, so the facilities that people were being mandated to go to were private facilities, so they were able to take people straight away. The money followed the offender. In a Scottish sense, it's a similar sort of health service to ours. It was still pretty seamless. So you went from court to the building that was adjacent to the court, and immediately you were assessed by the social worker, who I think was a probation officer, which is their system, and a nurse and everything else. But it was an incredible. It's an incredible system, and it works. And I think that's why we've been keen on it. Danny?
Yes, Chairman. Just to endorse everything that you've said, and Oliver as well. And I think the other thing that I would have to say about it is that it is not a soft option. No. There are remedies and there are sanctions which are used, and it is, yes, it is carrot and stick, but there is still an element of stick there that if people are not prepared to cooperate and help themselves, then you know that there are consequences for that. But it was a very useful exercise, both the visit to Brooklyn and Glasgow. And I mean, I would join with Alvin and contribute to your leadership on this, you know, for giving us the opportunity to explore these issues.
Certain something.
Sure, thank you. Yeah, I mean, I think that this type of innovation, whether it's everything from your alternative dispute resolution suggestions to this type of speedy resolution of a folks court, is of great benefit and very much worth our while looking at. But do we know what the size of the problem is in Northern Ireland and to what extent it would work for us? Would we have to, for example, my impression is there probably aren't enough, and not in a good way.
Yeah, no,
there aren't enough clients that are likely to need this on a daily basis.
Yeah.
So there might be a different style for Northern Ireland, and would that include, for example, bringing people from other parts of Northern Ireland to one central drug court?
Yeah.
Because it would seem to me would be quite difficult to arrange it elsewhere. So what are the sort of carrying on practicalities, and what's the extent of the issue for Northern Ireland?
Well, an opportunity is to explore that today later on in one of our sessions around the level of drug and alcohol misuse and the cost of the criminal justice system. I suppose it depends on what model you approach it with. You know, in the States it's a community justice model, so it's a community court that then is dealing with whether it be domestic violence, addiction issues, mental health courts, things like that. In Glasgow, it was set up as a specific court to deal with the heroin problems in the 80s and 90s, and that's why they established a court. I suspect we wouldn't have difficulty filling our drugs courts or addiction courts if we had one, but I think we could probably have less of them, and judges could direct some of the people appearing in front of them to the drugs court. And that seems to be the approach in Glasgow, that you may appear in front of a different sheriff, as they have there, and that sheriff may then redirect the person to go to Sheriff Wood's court, and if he thinks there is a justification for a mandated health approach as opposed to a traditional criminal justice approach, then he accepts that case. When we were there was a couple of cases he didn't accept, that it actually was around addiction issues, and he sent it back to the original sheriff and they would deal with them in a traditional way. So again, it's establishing what the problem is you want to solve, and then having the right approach that would suit the system that we have in Northern Ireland. And again, it would require health and justice coming together to say, look, we're going to have a joint approach in this. There has to be health money come into it to make it work. So again, it's something, if the department are going to buy into it and put it in programme for government, I think you could then look at the detail of it. But I think the principle behind it, from a cost saving and from an outcome led thing, is definitely
the principle is a sound one and a good one. It's just the extent of use and how we would deal with some of the practicalities of it in Northern Ireland. Thank you.
Yep.
I certainly concur with what Donny and Stuart have said, and it was good to hear Alban speak passionately and very interested in what he was saying, and obviously from his own legal background and practice, to see, you know, solutions that I assume would also reduce costs. And would that have been the case both in Glasgow and New York, that not only was it speeding up the whole justice system, but it was also reducing costs?
Yeah, I mean, both systems are quite resource intensive at the beginning of it, so you require a lot of people there in the courtroom, a lot of people who will give that wraparound very quickly. So there probably is a cost in terms of that resource. And where the savings are is in the longer term. You keep them out of prison, you stop them reoffending. Less of a societal impact if people are being more constructive. That's where the saving is. And when you assess over a longer period of time, there are clearly cost savings to the public purse. At the beginning, it will be resource intensive in terms of getting the right medical people in there. But again, the evidence speaks for itself. So. Okay, the other couple of items just on the independent inquiry report, synopsis of the Erne House fire. It was now published by the DOJ. It's online. The inquiry team prepared that synopsis of the report, and it was available for committee members earlier in the week before it was published on the website. Prison Services offered to provide an opportunity for myself and the Deputy Chair to view the full report, just to satisfy ourselves that everything that needed to be in the synopsis is. Are members happy enough if we do that? Okay. we will do that and then report back to the committee. Agenda item 4 is the Prison Service Director of Operations monthly visit report from Maghaberry. Members will recall that following the oral evidence session with representatives of the PGA on the 14th of January, reference was made to the monthly visit reports from Maghaberry Prison, and we'd requested copies of those reports. After that, the DOJ then said that it would be necessary to redact elements of that report for security reasons and data protection issues, and they offered to allow myself and Raymond to see the original versions to make sure that we were satisfied that everything that was going to be redacted wasn't necessary for the committee. We took up that opportunity, we read through the reports, and both myself and Raymond were satisfied that everything that we needed to see would be in the versions that were available to us. So the Prison Service has now provided a copy of the redacted versions of the reports there at pages 13 through to 249 of the table pack. There's quite a bit of stuff in there to get through, and members may want to use the next week to look over it before we've another session on the Prison Service stuff. But it's useful if members just do that over the next few while. Prison Service officials are here next week, as I said, to discuss Maghaberry Prison, the Earn House Fire Report, and have published the Sagini Summary Report and the follow-up inspection, which took place in January as well. So we'll have an opportunity to look at that and on the Prison Reform Programme at the end of that briefing session as well, if that's of interest to people as well. Item 5 then is Committee Forward Work Programme. There's an updated Forward Work Programme, pages 271 to 278. The Department's advised of a number of changes, including items of business which have been rescheduled or will no longer be brought to the committee before the end of this mandate, and they're outlined in the Senior Assistant Clerk's memo. The committee meeting on the 3rd of March, just to remind members that we're holding the meeting in the Council Chamber of the Law Society. It'll last no more than an hour and a half or so. It's a very light agenda, and after that we're going to go over to the Royal Courts for a roundtable discussion with the Lord Chief Justice and some of the other senior members of the judiciary on sentencing practice and guidelines. And that came about following some of the work that we've been doing, just in terms of the constraints that they're under in terms of sentencing, why certain sentences are given, and alternative sentences that may be useful to be available to them in the future. So it'll be a useful workshop if members can commit to going along to that. And then after that, we're having our dinner and our event with Lord Newburger in the Royal Courts of Justice as well.
Is that the following week?
Yes, 3rd of March. 3rd of March.
3rd of March.
Yeah. And that'll be our final innovation seminar. It'll be a useful sort of way of wrapping up the work that we've done over the last year. So again, if I would appeal to members to try to make sure they get along to that. It is kind of a big deal that he's come over to do this. We obviously met him before in London. He committed to coming over because he's interested in the work that we're doing. So if we can get a good show of the committee, it would be much appreciated. And if members can just confirm their attendance at the dinner and the event with committee staff over the next few days, that would be greatly appreciated. Okay, move on then to agenda item 4. Members will recall we agreed at our meeting on the 26th of November to schedule an oral briefing on the issue of wheel clamping in private car parks in Northern Ireland. Officials will attend the meeting to outline the policy and legislation relating to vehicle immobilisation on private land. Papers are pages 8 through to 168 of your meeting packs. If the officials want to step forward, I welcome Julie Wilson, Head of Operations Branch, Dorian McClintock, the Operations Branch of the Department. Julie, I think you're kicking off, is that right? And we'll open up the questions after that, so whenever you're ready.
Thank you. Okay, thank you for the opportunity to brief the Committee on Vehicle Immobilisation, or VI. We've already provided a written paper, but I wanted to take a few minutes just to outline the existing arrangements and to clarify what the role of the DOJ is. In Northern Ireland, vehicle immobilisation continues to be available as a deterrent against parking in areas where parking is forbidden or parking in breach of any restrictions that might apply. As a department, our policy responsibility is limited to vehicle immobilisation on private land, and this falls within our overarching policy remit for the regulation of the private security industry in Northern Ireland. Separately, then, other departments and local councils also have similar responsibilities in respect of on-street and off-street parking on publicly owned land. So in respect of what we do on private land, the Security Industry Authority, the SIA, is an independent body which was established under the 2001 Private Security Act. Its remit covers the whole of the UK, and it's responsible for licensing any individual undertaking designated activities within the private security industry, and this includes all individuals who are acting as vehicle immobilisation operatives. In order to secure a licence from the SIA, applicants are required to undergo criminal records checks and appropriate training. Licences are currently subject to annual renewal. VI operatives also then have to comply with a number of licence conditions, including they have to display their licence at all times, they have to advise the SIA of any relevant convictions or cautions or warnings they've received, and then there are a number of requirements which are specific to VI itself, such as providing receipts to anyone whose vehicle has been immobilised. Where an individual breaches their licence conditions or where they are operating without a licence, the SIA has powers to impose a range of sanctions, from a written warning or suspension of licence right up to prosecution under the Private Security Act. Just to clarify though, the SIA doesn't have powers in respect of how vehicle immobilisation itself is carried out. So by that I mean it's not responsible for setting standards on what signage there should be, or what the release fees should be, or what the release times should be. The SIA's role and its powers are focused instead on ensuring that the operators themselves are competent about what they're doing and that the industry is free from criminality. But in addition to the SIA, then there are other agencies and organisations that come into play in terms of accountability. In the first instance, if someone uses threatening or aggressive behaviour, then this is likely to constitute a criminal offence, and the PSNI would have an enforcement role, and they should be informed. In cases where there hasn't been any aggressive behaviour or threatening conduct, but where someone believes that they haven't been treated fairly, then they would have a range of options. In the first instance, they can complain directly to the company, and if they're unsatisfied with that, they can refer the complaint to the relevant trade association, and I'll come back to trade associations in a minute. Ultimately, if they still remain unsatisfied, they can initiate a case through the Small Claims Court, and they would be able to seek advice and support from a number of bodies such as Citizens Advice or the Northern Ireland Trading Standards Service. On the trade associations, it's worth clarifying that Driver and Vehicle Agency, DVA, requires any vehicle immobilisation company to be a member of an accredited trade association before it will release the keeper's details. So in effect, that means that VI companies and their operators are also subject to any conditions that the trade association will impose. The two key trade associations across the UK are the British Parking Association, the BPA, and the Independent Parking Committee. And of these, the BPA would have the largest membership within Northern Ireland. Both of the associations run approved operator schemes, and both of them have codes of practice, and members have to adhere to these codes of practice. And it's these codes of practice that cover guidance on issues such as what the maximum release fees should be, what the standards for signage are. BPA carries out annual audits for compliance, and it can take disciplinary action against members where they haven't complied with the code, and that can include suspension or termination of membership, which in effect would prevent that company from continuing to carry out VI activities. I'm aware that some committee members have received correspondence about vehicle immobilisation, and I know that there are, that concerns have been raised. Northern Ireland is the only part of the UK where VI on private land is still available. Across the rest of the UK, it was banned following concerns about serious malpractice and high levels of procedural abuse within the industry in those jurisdictions. As a department, we have taken those concerns seriously, and we have looked at what has happened in other jurisdictions, but we've also sought to ensure that we have the right arrangements here for Northern Ireland. So in order to inform our position on this issue, we have conducted two separate consultations, and we also commissioned an independent review to look at whether the similar problems existed on a similar scale in Northern Ireland. Neither consultation exercise nor the review provided any significant evidence of serious malpractice in the industry here in Northern Ireland. In response to our 2012 consultation, there were 10 written responses that touched on VI. 8 of them argued for some form of it to remain available so that landowners would be able to manage their land. We consulted again in 2014, and we did take a number of steps to try to publicise this consultation, but despite that, the consultation only received 12 substantive responses. And again, we would think that this indicates that there isn't the same level of public concern around VI issues in Northern Ireland as there were in England and Wales when they ran their consultation. The responses that we did receive were divided on the issue, but where there was opposition to VI, it was on the basis of, in principle, that VI shouldn't be taking place rather than any evidence of malpractice within the industry. In particular, some of the responses highlighted the importance of VI in the context of preventing and responding to parking infringements in places like hospitals and universities. So on the basis of these consultations and the information that we received, the Minister then took the decision that there was insufficient evidence to justify banning vehicle immobilisation in Northern Ireland, and that there are a number of means of redress for individuals where they don't feel that they've been treated fairly. Whilst the Department recognises that vehicle immobilisation can prevent or present a real inconvenience to a driver who has been clamped, this is balanced against the protection that it does offer landowners by acting as a deterrent to parking infringements. We're happy to take any questions that the committee might have.
Thank you very much. I just want to point out at the beginning, and I'm not disputing what you're saying, but the fact that there's only 12 responses isn't really an indication of how big of a problem or not it is. I mean, I've been here long enough now that members of the public don't generally respond to public consultations unless it's driven by a particular lobby group or organisation, and that tends to be how we get more responses. In terms of the number of cars that have been clamped in Northern Ireland in the last 12 months, do we have statistics on that or any information on that?
I don't think we have.
No, we don't have that. We don't have that information available.
So how do you determine how big of an issue it is if we don't have information on how many cars have been clamped?
We've really been looking at the level of complaints that have been raised with us and also the responses to the consultation. When the similar consultation was carried out in England and Wales, there was a huge response to it, and there was also quite a public outcry in the media as well, and we haven't seen that level of concern or those kind of complaints. We have had a number of complaints that have been raised, but they've been basically in the single figures. And
when you're looking at where those complaints are directed to, where are we looking at? I mean, are you talking to the police in terms of how many complaints from members of the public have made to the police or the Citizens Advice Bureau, or how many civil actions have been taken? Have you got all of that information? We've been looking at what the complaints that have been raised directly with us or that have come to us via MLAs. We're not aware of the police having received any complaints, and SIA has advised that it isn't aware of any complaints having been raised about PI in Northern Ireland either. Just to clarify, you checked with the police and Citizens Advice Bureau, did you? We didn't, no. It just strikes me again that if I was subjected to my vehicle being clamping, the first person I would contact wouldn't be the Department of Justice, it would be the police, or I would go to some other advice. I'm just trying to test this view that this isn't a significant problem. And you may be right, but I would have thought that you may have wanted to check after that consultation with other agencies that may have been approached. Is that something you intend to do? It's something that we can do. I mean, we can write to Citizens Advice and seek that information from them. But from what we have seen, when we have tried to engage in this issue, we haven't had a massive response on it. And then in terms of the monitoring of the operation of vehicle immobilisation then, so you mentioned how there's no powers for SIA to monitor release fees and release times and that kind of thing. Now, except what you said, there's other criminal behaviour, there's other avenues to go. But in terms of release fees and release times, I mean, Patsy had originally raised this issue, but I'm aware of constituents of mine who have contacted me around difficulties that it was one guy whose daughter had her car clamped on a Friday afternoon. She wasn't able to get through and get it released until the Monday, and that impacted her, doing her daily business and impacted her getting to work on the Monday. So who is there to monitor how that works in practice then if the SIA aren't able to do it?
Well, in the first instance, it is a matter for the company that the person who's been clamped that would take that up with the company. But then the trade association, so most likely the British Parking Association, has a code of practice. It does audit its members against that code of practice. Code of practice sets out things like what size the signs should be, where they should be, how visible they should be. It establishes things like how long an interval there should be before action is taken in terms of immobilising a vehicle, and also it covers things like release times as well. So whereas a company isn't acting in compliance with those with the code of practice, the individual can take it up with the BPA.
What sanctions are available to the BPA against individual operators?
BPA issues sanction points, and if a company gets more than a certain number of sanction points in the course of a year, then they can lose their membership from BPA, which then means that if they're not a member of that trade association, then DVA won't release keepers' details to that company, so effectively they can't carry out VI. So that is one strong sanction there. BPA also, they would publish on their website where they don't list the names of companies, but they do publish details about where they have issued sanction points against a company.
In terms of the other point that was made then, that hospitals and universities, in terms of having large car parks, sometimes require this type of intervention. How do universities and hospitals in England and Wales cope then if this isn't allowed anymore?
They use ticketing, essentially, is how it has been dealt with in England and Wales.
Danny?
Oh, thanks, Chair. Thank you very much indeed. Thank you. I think my experience as a member of Assembly has been where representations have been made by aggrieved members of the public who either have had their vehicle immobilised or received a fine, particularly for parking in private retail areas. Now, and I understand that previous experience gives me some insight as to how parking charges and they're not popular at the best of times, but how they are applied, right?
Sure, if there's any.
One of the difficulties that we've had is that some of these private companies are largely based in GB. They issue them the fine, or if it's a fine, they accept it. It's slightly different to immobilising, where more urgent action is required. But people generally receive in the post details of a fine. Where I come from, there are what might be described as barroom solicitors who advise people to simply ignore such correspondence and that it will have no consequence. I'm always nervous about advice of that nature. What is what are the legal implication for someone to ignore a parking notice issued from GB in respect of this? Is there can they be pursued through the courts here if they remain unpaid, or does the individual's credit worthiness come under question, or can it come under question if they remain unpaid?
To be clear, the department's responsibilities don't cover the issuing of those notices and the penalty fines. It's simply the licensing of individuals to carry out the immobilisation. I know on public land where someone gets a parking notice and they don't pay it, then at that point clamping can be used and for non-payment of fines and for debt recovery. On private land, as a department, we're not responsible for that, so I'm not sure what the answer to the question is.
That creates a gap in information that none of us are able to, with certainty, give advice on. And, that I would have thought somebody should know what the implications are, or what the company who's overseeing this on behalf of the retail development or whatever, what duties have they got, or what sanctions can they further impose on someone who remains? I mean,
It's something that we would have to look into, simply because it isn't within our responsibilities as a department, so we just don't have that information.
I mean, I don't know, Chair, if that's been a common experience for any other members, but that on any number of occasions has been brought as a constituency case. And to give proper advice, I think, is what we would seek to do on it. It seems to me that somebody ought to know what the implications are, or how, to provide best advice on it.
Those issues are dealt with, again, under the BPA Code of Practice and the other trade associations Code of Practice. There's guidance laid out in situations where parking notices have been issued as well, but as Julie says, that's outside of our remit within the Department of Justice, but there is certainly guidance there under the trade associations.
But it could come back into the Justice remit if the GB company decides to take action involving, the police and other agencies.
Again, we would need to look into it. My sense is that it would be a civil action, but we would need to check, because it's not something that we've looked at, because it is outside our department's responsibilities.
Thank you.
And can you come back to us with that information then?
Yeah, we can.
Yeah.
Yeah, that's confused me straight away. Your officials within the Department of Justice who looks at this, having said that, of course, you've no regulation over this. But that simple question from Danny there is, the truth as I understand it is, that once you receive a charge in the post from these companies, you can choose to ignore it. You have that right. The parking companies can take you to court to retrieve that money. But most times, in fact, all times in Northern Ireland to date, they've chose not to. So you can ignore it, and the chances are they'll send you 3 letters, and after they get to a point where they have
This is dangerously close to barroom solicitors.
they have basically exhausted enough money that they're fine. Basically, they won't retrieve the money back. Then they cease writing to you, and that's been my experience over and over and over again.
But what's the creditworthiness issue?
Sorry,
Is there any issue of creditworthiness that is impacted upon?
I don't understand.
Can effective? Sorry, through you.
Oh, okay, work away, yeah.
Can the chair? Or sorry, can the company block somebody
That's
in terms of their creditworthiness?
they can gain access. As far as I'm concerned, as far as I know, my understanding is that they can gain access to records, but I'm not sure that they can actually do something on those records. But again, that's why I'm amazed that the officials don't know the answer to these questions, because they are fundamental to people's rights here in regard to this. And I know private landowners should have recourse and redress when it comes to parking. I have absolutely no problem with this. The issue I have is that when you clamp someone or you immobilise their vehicle, you sting them twice. You punish them twice. Because you not only have to pay them to remove that clamp, but you are stuck there. If you're a single mum looking to get to a nursery to pick up your child and you've been clamped, you're in diffs. If you are someone who needs to get to work and you can't get to work because your car's clamped, you're in diffs. You could well end up losing money, more money because of your job, or you could be in trouble in your job. When you get clamped, you're stung twice. And that, in my eyes, is unacceptable. Why do officials not know the answers about can this money be claimed back or retrieved, or if it affects your credit, really?
We're not responsible for policy around ticketing. It's simply around the regulation of vehicle immobilisation. So that we have never looked at that issue because it doesn't fall within the department's responsibilities.
But it could well be going back to what the chair says, it could be a big issue and you just don't know. And do we not think we need to know? Do officialdom, do they not need to know the scale of this problem when they're deciding some sort of, when they think it's fit to consult on it, but yet not know and not inform itself on the ins and outs of it? Is there not blind spots here?
Our consultation has been purely on the issue of vehicle immobilisation and the public response to that. And like I said, when we did consult, we got very few responses. The responses that we received were mixed. We did try to promote the consultation, we tried to publicise it, but again, it just didn't generate that level of interest.
Yeah, but I still think that officialdom should be trying to inform itself through other guises and other ways. How often do you speak to the BPA?
We've spoken to them in a number of times in advance of this, but it's not something that we have been looking at regularly, simply because we have other issues that we've been focusing on, and after having consulted on this, it has only been raised in a handful of occasions where individuals have written. Where they have written, we have passed cases that they've raised with us to the BPA and asked the BPA to look at those.
This was debated. This was a motion brought by myself to the floor of the House of this Assembly, but yet we are still in a position where there's so many blind spots in the department. Who pays for the BPA?
I imagine it's paid through membership of
Parking companies.
the members of the trade association.
So would it be in the best interest of BPA to sanction any of its members?
I think that is a matter for BPA. They do publish the figures for sanctions on their website, and they're publicly available.
If you were parked, I can understand why we have to regulate or restrict parking. If you're blocking somewhere like a hospital, I can see why you'd want to punish that person who's blocked that lane into a hospital. How is clamping that vehicle improving the situation when that car has blocked something?
The clamping acts as a deterrent, is what we've been told. It stops people from parking where they shouldn't be parking in the first place. It's more of a deterrent than other forms.
Is a fine not a deterrent?
Well, the hospitals and certainly the universities would have said that clamping was the most effective deterrent.
So if you park in a place you weren't meant to park and it blocks either a business or a hospital or somewhere else of that nature, and you get clamped on a Friday morning, and you may not get that clamp lifted until the Monday morning, there's a lot of damage done there with regards to the whole weekend. But that private landlord sees fit that that's better than putting a ticket onto a windscreen and trying to get money, retrieve money, or a charge. It's not even a fine charge. I don't see how that could help the private landlord.
Well, that was certainly the representations that we received at the time of the consultation.
The consultation brought issues out with regards to the principle of VA, but the Minister seems to have chosen to ignore the principle and only look towards malpractice, and he sees no evidence of malpractice, so he ignores the principle of vehicle VA. Why will he not look at the principle, especially when we have it banned now in Scotland since '92 and England and Wales since 2014, I think?
I think it's not that he hasn't looked at the principle. I think it's that he took a look at all of the responses that we received and balanced them. So against the principle, in the absence of evidence of malpractice, there was the argument coming from the hospitals and universities saying, actually, if we don't have this, we lose control of the management of our car parks, was how they said it. So it wasn't that he disregarded, it was that he balanced.
And who responded to the consultation then? The 12? Who were the 12 respondents?
There were
16, were there?
There were there were 3 individuals who had responded.
I don't need to know individual names. Tell me the organisations who responded.
There were, do you have them there?
Yeah. Disability Action, University of Ulster, Fermanagh District Council, the British Vehicle Rental and Leasing Association, the Environment Minister, the Western Health and Social Care Trust, the Legal Services Commission, South Eastern Health and Social Care Trust, the Ambulance Service Care Trust, the British Parking Association, Citizens Advice Bureau, Law Society, British Motorists Association, and then 3 members of the public.
And can I ask, how many were against banning VA?
Was it 6?
Yeah.
6 were against.
6 out of, sorry,
Out of 16, is it? 16.
6 out of 16. And the other 10 were for continuing VA. Is that correct?
I think 4 didn't respond substantively on it, so there were 12 substantive responses. I think in the first consultation in 2012, 8 had argued for retaining it in some form. 1 had argued that it should be banned, and 1 had argued that it should be carried out only under legal authority. And in the second consultation, I think 6 argued against and 6 argued for.
The first consultation wasn't on VA though.
Not
It was
specifically.
about security.
It was
There was
about
a
the
section.
wider.
Yes. And the second consultation was on VA
Specifically, yeah.
specifically.
Yeah.
There are times whenever cars are found to not having tax and insurance, those cars are clamped on the side of the road, isn't that right?
I understand.
That would be in public.
That would be in public. That would be more acceptable by the fact that when those cars are driven without tax and insurance, they are a real danger to the public. If you click or crash or connect with those cars, or they connect with you more like, then there's a real problems there for people when they get injured. So you can understand that there's justification there, but I still regard being clamped in a private car park as a double dunt of punishment, because you have to pay for it to get off and you're stuck there until you can get some way around that. Is there any plans for the Minister to look at this? I know we're coming to the end of the mandate, but is there any?
At the minute, there aren't any current plans. If that's something that the committee would like us to take back to the Minister and ask him to consider, we can do that. I think we would need to carry out a regulatory impact assessment, given that we haven't previously had any real significant evidence of malpractice, and there would be, if we were to stop vehicle immobilisation, there would be an impact, I think, on businesses and on employment, so we would need to do that regulatory impact, but we can go back to the Minister and ask him if that's something he'll consider.
Yeah. There's always the further consideration stage of Justice Number 2, Bill. Thank you, Chair.
Holden.
Thanks very much, Chair, and thanks very much for your presentation here today. It seems to me that I know that the consultation was well intended and so forth, but it really was based on the premise of whether or not there was malpractice, whether you should deal with that malpractice. There wasn't any real interrogation of whether or not, in principle, this should be permitted. And I think that is a failing in relation to it. But I'm surprised that no motoring organisations responded. Did you talk to them, or AA or RAC or people like that?
We didn't target them specifically, no.
Well, it would have been a fairly obvious organisation
I
to
mean,
target.
the consultation was widely publicised, but we didn't specifically go to those organisations.
It may well be that there isn't such a huge problem here, but there's still, I mean, as Mr. Frew has pursued it very thoroughly, I mean, there is the principle of whether, there should be, it should be permitted to clamp somebody at all private land. And then there's the other issue, if that is permissible, then how do you regulate it? Now, what I would like to ask is, what is private land? I don't want to go into a big legal discussion about it, but it seems to me that a university or a hospital, doesn't strike me that that is private land, although technically you may say it is private. But I would have thought a hospital and a university, in order to regulate its traffic and parking and so forth, should have some way of dealing with that, and clamping may be the ultimate deterrent. But when you come to other, what I would term real private land, it seems to me that it's less acceptable. I mean, that's my instinctive reaction to that. I mean, did you explore that at all?
But those, I mean, private land would include hospitals and universities, certainly as part of our
Are
consultation.
they not owned by the public?
The land, the car parking area would be considered to be private, but it doesn't fall under the definition of public roads or public space. So they're certainly included as part of this.
Even the university?
Yes, the university as well. But we do know that there are a small number of people who are licensed to carry out vehicle mobilisation activity in Northern Ireland.
Who licenses them?
The Security Industry Authority licensed them.
Yeah.
And at present, there's 36 individuals who are licensed to carry out that activity. So, from that perspective, we know that it's a relatively small number. As we said before, we've had a few complaints, but they have been relatively few when we've been trying to gather our evidence as well.
But, I mean, I go back to Mr. Frew's point. It's been banned in England and Wales, and also in Scotland, effectively outlawed by the court in a case called Black and Carmichael. And I've just seen a quote where the judges concluded that it was, in cases, extortion and theft, which is, very condemnatory of the practice itself.
Judge must have been caught.
But it does strike me that in this instance the department is just simply saying, well, there's no real problem there, so let's move on. And I don't think that's quite right. I think that we as a committee seem at least to be taking a contrary view, that this is something that ought to be explored by the department further.
Certainly we can take that back to the Minister.
Yeah, and
concerns.
see, even if you accept the principle that you could do this, and I don't know whether it's lawful or not in Northern Ireland, because it probably hasn't been tested. I don't think it's been tested in court. But even if that were so, say I park in somebody's private land, not even saying a car park incorrectly or something like that, but on private land, and somebody says, well, I've just clamped your car, now pay me £1,000. Is that acceptable?
In order for someone to do that, they would need to be licensed by SIA, and they would need to be a member of the Registered Trade Association.
But could that amount of money be demanded of a person?
There is, I mean, there's guidelines set for the amount of money which is considered acceptable, which is £125 for a private car.
Yeah.
Before they could clamp you, they would have had to have displayed signage telling you that you're not able to park there, which has to be of a particular size and well displayed. So there's steps which have to be in place, and if they don't follow those steps, then there's recourse which can be taken against that.
And what's the recourse?
Well, the complaint made first of all to the company, a complaint to the BPA if they're the trade association, and following that, if it's considered to be a criminal act, then to the police, or there could be action taken through the small claims
Well, it's
court.
hardly a criminal act, is it? It might be unlawful, but it's not criminal.
The police really would only get involved if there's violent or aggressive, conduct,
Yeah.
and otherwise it would just be you could take a claim through the
Small claims court.
where someone has clamped you without being licensed. That is a criminal offence.
That is criminal.
And that can attract 5 years when tried on indictment. So
Any examples here? No.
not in Northern Ireland. So.
All right. Thank you very much.
It just seems an awful lot of work for an individual to have to go through if they find themselves in this position. They're finding out whether the person who clamped their vehicle was licensed, and going through all the rigours of the company. And as Paul said, the body who's taking the fees from companies isn't going to be really incentivised to see them go out of business, because that's where they get their income from. It just strikes me as a very imperfect system. Alex?
Thank you. But it's more to probably just to echo some of the points that have been made. As Doreen confirmed initially and then subsequently, BPA is a trade association whose primary job is to represent its members, and on the side does a bit of regulation. And I don't put any confidence in them as an organisation. In a different job I had, I actually met the BPA in London. And unbeknownst to me, the meeting had been arranged they arranged the venue, which was a restaurant. So we had the meeting, but I didn't take lunch because their approach is a minimalist one in terms of interventions against their members. And why wouldn't it be other than that? Because their members pay for the organisation and pay their staff wages. So I'm very cautious about the BPA as an organisation, and I saw them up close and personal and how they went to extravagant lengths to defend their members. So the questions I would have is for you to provide to the committee details of how many of their members they've suspended or expelled over, let's say, the last 3 years, both over in Britain and here. The second point is the one that Albin and Paul have made. The principle here should be to protect the citizen, not to simply protect what the BPA say is and what other people say the needs are. And I do think the department has got this wrong. That given the concern generally about these enforcement organisations, and there is a lot of concern about them, the point that a judge says that they are guilty of extortion. I'll come back to that point. The principle should be put the citizen first. And whilst you may say this was the evidence of the consultation, and of course I accept that, nonetheless the role of departments and ministers is to stand back and say, hold on a second. What is in the interest of our citizens, given the experience of so many here and over in Britain that led to this particular thing's stopping? And the third thing is, that's all corroborated in my view, that the principle of not these businesses is extortion. It is, let's write nasty letters, say that they're going to get blacklisted, demand maximum penalties that are completely disproportionate to any loss that the landowner might claim. This is in terms of the car parking immobilisation. It is to try to get as many people as quickly as possible to pay the maximum amount. And they never go to court, because they've never gone to court, because it's highly problematic whether there is any contract in the terms that these organisations claim. And that's why a lot of the times they just back away, because they know they haven't got the law on their sides. So given that profile and that experience, and I hope DOE told you that that was what their experience was, I think the department is in error here. The department should again look at this, and one way or the other get into a banning of this, and then look at the wider issue of regulation of what these people are getting up to, and work with the Department of Transport in London, because they have powers in this regard, if my memory serves me right. And it would be one of the most popular things. It would make the Assembly relevant to a lot of people who feel threatened and bullied and extorted by these organisations saying, stand and deliver your £140 or we'll take you to court and get you blacklisted.
I'm going to fail to respond, or whether to respond, or
I think it was advice rather.
I'm sure there was something of a question there somewhere, but
I concur with all the other questions.
As I said, we can go back to the Minister and we can suggest that he looks at this again.
Sammy?
Chair, I agree with Alex is saying, but there's another side of the coin here. I was in a meeting this week not far from here, in Cumber Road, where residents are, I was going to use the word tortured, but really angry because people parked in their driveways, couldn't get out. Also, we would know of, like in housing estates, where people come and the block off people can't get the prams out. While I'm agreeing with Alex, I'm asking the question in terms of the breakdown of figures. Would there be a breakdown of figures about, say there's 100% or 30% of those people parking on double yellow lines, or they're blocking people's homes or driveways or whatever? Because that is a big problem for many people right across Northern Ireland as residents, been blocked in by people maybe illegally parking.
Our responsibilities are purely around the private land, and it would generally be where a company has been contracted to carry out that vehicle immobilisation, and our role is to ensure that the people who are doing it are licensed. So in terms of people parking on double yellow lines or parking across a driveway, that wouldn't, but I think that would fall under DRD, and Transport NI would have those responsibilities.
Thank you, Chair.
Just on that, because Sammy raises a very important point. If you're obstructing a driveway, it is a police matter. If you're on a double yellow line, it's a roads matter, and that's where you would get the ticket that you must pay, and that's the fee. I think is it £60 off the top of my head. 30 going up to 60 or something of that nature, and those are fines that you must pay.
Chair, I agree with Paul, but we all know during the police, the police are overstretched, underhand. Those are sorts of issues.
There would be no jurisdiction or justification for clamping somebody in that situation. And again, I'm not opposed to private land regulation and restriction and fines for people parking inappropriately. But we do have instances where there's manned car parks. The man or woman watches someone walk out of that car park to go and do shopping elsewhere, doesn't warn them or inform them that they risk having a fine, and then their car is fined or their ticket is slapped on. So there is an ethical thing here also, because you have to ask and wonder how these companies are employed to do this regulation or actually get their money. And it may well be the case that they get their money through the fines that they bring in, and that adds a whole other list of questions to the equation. I do think that the officialdom must look at this more closely and come down. I just don't agree with immobilisation. I think it's a double dunt and should be taken away and only used for cars that are not taxed or insured, which is a different situation altogether.
Okay.
We'll take that back to the Minister.
Okay, well, look, I think fairly confident to say that the mood of the committee seems to be that this is a problem, and perhaps the department may want to relook at that in the next mandate, because I suspect that the next committee may want to take this issue further, and you can maybe reflect that to the Minister.
But, Chair, I think the point Paul makes is not against regulation, but he's against, in principle, mobilisation, because it's such an excessive and disproportionate measure to use against a person. And I think that should be strongly put to the department.
All right. Okay. Thank you very much. Thank you.
Thank you.
Okay, members, move on then to agenda item 5. Members will remember at the meeting on the 1st of October we agreed to schedule an oral briefing on the impact and cost of the criminal justice system of substance misuse. So we're going to have officials attending today to outline the impact and cost of the criminal justice system of alcohol and drug misuse. Papers are on page 171 through 433. So if their officials want to come forward. And as they do, I'll introduce Stephen McCourt, Acting Deputy Director of Community Safety Division, Deputy Director Superintendent Brian Hanna, Geraldine O'Hare, Head of Programmes and Interventions, at the Probation Board, and Stephen Davis, Acting Director of Operations of the Prison Service. You're all very welcome. I don't know who wants to kick off or make some introductory comments. And then
Chair.
That's fine, then we'll open up the questions afterwards.
That's great, Chair. Thank you very much. We're grateful for the opportunity to brief the committee today on the impact and cost of alcohol and drugs on the criminal justice system. Members will already receive the written briefing, which I hope provides an indication of how the misuse of alcohol and drugs can and does impact upon the justice system. To provide some context, almost 3/4, that's 73% of respondents to the 2013 Adult Drinking Patterns Survey reported they drink alcohol, and further analysis reveals how 11% of those who drank in the week prior to the survey were likely to have a problem with alcohol. The 2014 census of drug and alcohol treatment services in Northern Ireland states that there were over 8,500 people receiving treatment for the misuse of alcohol or drugs. Almost half of those were in treatment for alcohol only, and 1/4 in treatment for drugs. The number of people in treatment reflects an increase of over 45% from the previous year. Efforts to reduce the harms caused by alcohol and drugs are set out and coordinated through the Executive's new Strategic Direction on Alcohol and Drugs, more commonly known as NSD. NSD recognises how misuse has and continues to be a significant public health and societal issue, and sets the policy direction for reducing the harm related to alcohol and drug misuse across Northern Ireland. Whilst led by the Department of Health, Social Services and Public Safety, the justice system is a constituent part of the overall response, as substance misuse has long been recognised as a factor in offending behaviour. Accordingly, NSD outcomes are broadly reflected in the Department's community safety strategy. The committee will shortly receive an update on progress against all of the things included within the community safety strategy, and whilst I would not wish to provide detailed comment on the content of that update, there is clearly a direct read across with the discussion today. As a result, I think it's important to reflect some of the work of the Department and the wider criminal justice system in seeking to address the impact of substance misuse, after which I will come to the issue of the overall cost of the justice system. Action taken in support of the NSD can be summarised into the areas of work that seek to reduce demand, restrict supply and build recovery. Our efforts to reduce demand include the work of the policing and community safety partnerships. Throughout the past year, PCSPs have delivered a range of initiatives aimed at addressing drug and alcohol issues at local and regional level. By way of illustration, in Derry and Strabane, a first offenders alcohol education programme targeted on street drinkers. In Antrim-Newtownarby, an education and awareness raising programme also provided a counselling element for those who require assistance with drug or alcohol dependency. At a regional level, PCSPs are also at the heart of the Drug Dealers Don't Care campaign. This is due to be relaunched on 24 February. Reflecting the joined-up approach, partner agencies such as the PSNI and PHA and local service delivery organisations also schedule other drug awareness and enforcement initiatives to align with that campaign. Moreover, illustrating the Department's commitment to maintaining and improving the links between health and the criminal justice system, local PCSPs have been encouraged to work closely with the newly established Drugs and Alcohol Coordination Team Connections Service. This service aims to build on the existing relationships and will provide assistance in both the planning and delivery of any alcohol and drug-related actions, activities or projects over the next 3-year period. In terms of restricting supply, the Department continues to support all efforts to reduce the availability of illicit drugs. The written briefing provided to members highlights how proactive, intelligent-led policing operations are continuing the fight against organised crime gangs profiting from this type of trade. The Organised Crime Task Force Drugs Expert Group continues to meet to share information and intelligence, as well as lead joint actions. The PSNI, UK Border Force, NCA, HMRC and other law enforcement partners continue to use intelligence to disrupt importation and carry out a range of operations targeting both high-level suppliers as well as street-level dealing. The drug market in NI has continued to develop alongside other parts of the United Kingdom and Europe, and the illicit supply of prescription drugs remains a concern. Work continues to disrupt importation of drugs, including prescription medication via the internet. Seizures of quantities of illicit counterfeit prescription or over-the-counter drugs where it is believed there is an intention to supply continue to be made. The global enforcement campaign, otherwise known as Operation Pangea, has been particularly effective in this area. The existence of new psychoactive substances has required law enforcement agencies to be innovative in developing their response. The devastating consequences of these uncontrolled substances are clear to all. The success of the collective action taken against retail suppliers of these substances by Belfast City Council was a testament to the working in partnership to utilise the powers available through existing legislation. In terms of developing the legislative response, the Psychoactive Substances Act, as a piece of reserve legislation, will fundamentally change the approach across all of the devolved administrations towards the illicit supply of these substances. Members will have received a separate written briefing from the Department in this area, and we will continue to work with the Home Office and others across Northern Ireland in preparation for commencement on 6 April. In terms of the final strand, building recovery, it is recognised that substance misuse, despite a range of healthcare interventions, can result in an individual entering the criminal justice system through their offending behaviour. Conversely, it can also be the case that an offender may have never sought or been involved with the health system. This highlights the importance of appropriate screening and assessment tools, as well as the tailoring of appropriate interventions at treatable moments throughout an individual's journey through the system. Opportunities exist in youth conferencing for those young people involved in substance-related offending to hear from those who have experienced and addressed dependency in order to reduce the likelihood of re-offending. Informed by the new commissioning framework arrangements, cooperative working relationships continue to be developed with a range of service providers to deliver reparatory replacements for young offenders who misuse substances. For the probation service, treatment options can be a requirement as part of a probation order for the whole duration or part duration of the probation period. When offending behaviour results in a period of detention, the prison service works with the South Eastern Trust to educate and support those with addiction issues. This partnership approach also ensures that discharge structures are in place to provide the appropriate continuum of treatment and support to prisoners returning to the community following release from prison, or indeed those on home leave. The written briefing outlined how alcohol and drugs impact upon the system, and I have tried to highlight some of the actions the Department and wider criminal justice system is taking to address that impact. In terms of cost, the written briefing also included a number of estimated figures, which I hope brings into focus how pervasive substance misuse can be found right across the system. The publication referred to in the written briefing highlighted the social cost of alcohol misuse in Northern Ireland and included a financial assessment of those costs that relate to the justice system. It is also important to reiterate that no formal departmental assessment of drug-related costs has been undertaken. Based on the number of qualified costings included within the written briefing, however, it is clear that if a comprehensive assessment was undertaken of the impact of both alcohol and drugs, the combined figure would be substantially higher. In closing, I hope the written briefing and the evidence provided today will provide greater insight on the impact, overall response and cost to the criminal justice system associated with the misuse of substances. I would like to assure the committee that the Department and the wider criminal justice system is very aware of the impact that alcohol and drugs can have on individuals, families and the wider community. We remain committed to focusing our efforts in partnership with others towards the delivery of the outcomes contained within the NSD and playing our part in the overall response to substance-related harm across Northern Ireland. Thank you, Chair.
Okay, thank you very much. This is one of those issues I think everybody acknowledges that there is an issue there and a problem there, and how we solve it maybe traditionally hasn't been particularly good. When we talk about substance abuse, I want to leave the alcohol aside. I think we all appreciate it. There's a societal problem with alcohol in the UK and Ireland, and there probably always will be unless we have a real shift in terms of our culture. Looking at the substance abuse, though, I was in the Monkstown estate this morning, and I was talking to some of the people who run the community centre there, and they were talking to me about young people who had been around last weekend, smashed a number of windows, pensioners, bungalows, things like that. And they were having what they called skittle parties. And I'd never heard of that before. Have any of you heard of a skittle party? This is this phenomenon that they are stealing prescription medication from their parents or from their grandparents. They're meeting up, throwing it in a bowl, having a bottle of vodka and picking some tablets out of a bowl. And that's what they're doing at weekends. And likewise, the psychoactive substance bill, as good as it may be and may help in terms of closing down head shops, I think we're all aware of the shortcomings of that bill around chemical compositions being changed. Online, you can get any number of so-called legal highs delivered to your door. So there's no difficulty in terms of law enforcement in preventing that from happening. I suppose what I'm trying to ask is, when we talk about substance abuse, what are the main areas that are causing difficulties in the community out there? So not just young people, but what kind of substances are being abused? And when we talk about illegal drugs, what are the illegal drugs that are being used at the moment? And again, last week we were in Glasgow, and they had a real problem with heroin in the 80s and 90s. And you could see by the age of some of the people who were going through the courts, they tended to be older people who were addicted to heroin. Some of the younger ones were on cocaine and legal highs and things like that. What is the landscape of drug abuse in Northern Ireland at this present moment in time?
Mr. Chair, if I take that, over the last 12 months we've seen an escalation in cocaine and cannabis, which is the preferred drug, the legal drug of choice at the moment. We don't, thankfully, have that significant risk in relation to heroin that there is some perception about, but it's very low in Northern Ireland. But we have seen a marked increase in cocaine this year. We've seized at least another £1 million worth of street-level cocaine this year, and probably around the same in cannabis.
Sammy's not here, and it's maybe unfortunate, because I remember him raising an issue that there is a bit of a rise in heroin use, isn't there? I mean, I remember there was needles found in East Belfast, and Sammy had raised that issue. Is it becoming an increasing problem again?
It's not clear whether it's specifically linked to heroin. People using steroids as well are using needles and that. So, there is a perception there that there's a specific issue around it. There is a notable increase in some crime linked to heroin use, but heroin use is roughly about 0.1% of the population of Northern Ireland. About 1,500 sort of known heroin users in Northern Ireland. It's really tiny in comparison to the rest of the UK and Ireland. But in saying that, we've over the last number of months been a number of operations, specifically in the South Belfast area, in relation to the sort of heightened concerns. And we have identified and subsequently arrested approximately 30 individuals for street-level heroin supply. Now, that, but again, it was very, very small quantities, so it is,
And I know our members want to come in, so I'm not going to ask too many questions around this stuff. We'll come in again later on. In terms of the approach, and again, it's something the committee have looked at over the last year, particularly around. Sometimes we look for a criminal justice response to a problem rather than perhaps potentially a health response to a problem. And we know that many people with addiction issues are stealing or getting involved in criminality to feed their drug habits. So unless we fix the addiction issues, we're not going to stop them reoffending. And I think we've bought into the concept that sometimes prison is not the place to go to for those types of offenders, particularly when we get reports like the Cegini report that shows us how easy it is to come across drugs within the prison estate too. You're certainly not going to fix somebody's offending habits when that's the case. So is there an appetite amongst all of the agencies for looking at different approaches to how we deal with offenders? Because again, where it's worked in Glasgow, where it works in the States, police are bought into it, the district attorney or the prosecution service are bought into it, the politicians are brought into it. Is that appetite there for a different model, so whether it's a problem-solving model looking at mental health courts, looking at drugs courts or domestic violence courts, whatever it may be? Is that appetite there now that we can actually be bold and move forward with it?
Maybe I'll take that, Chair. Yes, I absolutely think that the appetite is there. I think you know, you've got two vastly complicated systems such as justice and health, and I don't think either can actually crack this problem on its own. And you're absolutely right to identify the link and the correlation that we know from years of practice, but also from the research and the evidence, the links with people that have significant substance misuse, alcohol problems, addiction issues and mental health. So, you know, simply the justice system, these people don't simply enter the justice system having an addiction problem or a mental health problem. You know, as you said, it's a societal problem, it's a public health issue. And I think that the agencies all must work together. And I extend that not only to health, but also to education as well. I think, you know, if you look at the statistics, 1 in every 11 children are living with parental alcohol and substance misuse, you know, so it has to start. And I think we need to tackle the early years interventions, you know, in order to educate children, teachers and the education system. So, you know, both health and justice have a primary role here to play in working together. I think the justice systems, the justice family, are certainly signed up and work very well together, you know, in terms of the justice journey, because clearly from a probation perspective, we work with the offender at every stage of that journey, from pre-sentence to complete an assessment to identify the level of risk, the level of substance misuse linked to their offending. Whether or not then they receive custody, then the prison service are clearly picking up the gauntlet there and working with them. And then there are very clear sanctions in place through testing, etc., but also when they're being released from prison in terms of licence conditions, which are very robust deterrents, I believe, you know, that people are actually being tested, you know, through licence. And also, you know, a range of services that are available both in the community and in prison. So I think from a justice perspective, clearly we are signed up. I think health, there's great initiatives that we have worked over the last few years that Stephen has referred to through the PHA, where, you know, you have health and justice working together with the same outcome in mind. I think there's lots of new initiatives which you referred to yourself, such as the problem-solving courts, which are a diversion, an opportunity to divert and rehabilitate problem drinkers and problem people with significant substance misuse problems. You know, our profile within the probation board, at any one day we supervise approximately 4,500 offenders. 73%, 74% of those offenders would have an alcohol or substance misuse problem, which is horrific. You know, it's a very serious, very high number of offenders that we're working with on a day-to-day basis. 66% of them, being males, would have alcohol problem. 90% are males, 10% are females. 66 of that 90% would have significant alcohol problems, and 51% of females would have an alcohol problem, both, you know, with substance misuse as well. So, you know, just to respond to that, I think it's a wide-ranging societal problem that health and justice do work together, but clearly the justice family, I think, are have significant appetite to work together to resolve this.
If I could just add to it, Chair, in terms of, the committee will already know in relation to the fact that OECD have undertaken a report, and a wider report being led by DFP at the moment, and one of the specific aspects we've asked them to look at is about problem-solving courts, and I know the committee are very engaged in relation to that, and the Minister has spoken to you in relation to his views. The Minister is open in relation to looking at the problem-solving court process in that respect, but as the committee rightly pointed out in relation to your experience in relation to Glasgow, etc. This requires a cross-executive approach in relation to looking at problem-solving approaches within the court setting.
I mean, I think that the thing that strikes me most, even just looking at the evidence before I've seen it in action itself, is that the reoffending rate is so much lower when you have a problem-solving solution to the issue. So when you ensure that people are having regular testing, when there's incentive for them to stay clean or get themselves clean, and it works. This stuff works, and when it works, it's not just about reducing reoffending, it's about saving the taxpayer money. I think that the observation that we had, particularly in the Glasgow, was how resource intensive it may be at the beginning, but there are significant savings to the criminal justice system if you take that approach. Where I do get some concern around the Minister's approach on this, and I must say it, and Danny pointed this out in the debate during the week. I mean, the Minister was aware of problem-solving courts. He visited Red Hook 3 years ago. Nothing has come forward from the Department around a different solution to these sorts of issues. There's been nothing from the Department around problem-solving courts until the committee began its work on innovative approaches to justice, we hadn't heard the department say anything about problem-solving courts. And it shouldn't take the OECD to come and give us a paragraph in their overall report saying this might be something that's worthwhile looking at before the Minister comes forward with these ideas. And the second thing that I have a concern about is when the Minister was here a few weeks ago and we mentioned about the Fresh Start talk, the Fresh Start agreement, where there's money there available when two departments come together. That was a prime opportunity for the Minister to say, do you know what, the next programme for government, I'm going to look at problem solving. Courts are going to look at problem solving solutions, particularly for these sorts of issues that we're talking about today. He didn't say it. Even when he was prompted, he didn't say it. So I'm not sure I have the confidence that actually the department and the Minister is pushing in the right direction to have a collaborative approach between health and justice on these issues, because I haven't seen the evidence of it. I know it's more of a comment, you're not going to answer that question. But I do think we have an opportunity now, leading up to the new programme for government, that if we are serious about this, that the Justice Department should be making the big pitch, saying we want to work in collaboration with health in looking at alternatives to criminal justice solutions to some of these issues around substance abuse. I'm just not sure that I have confidence that that's happening with the Minister of the Department. Sean?
Thanks, Chair. In terms of the figures and costs, 900 million, does that include health, or it's in 900 million per annum with the cost figures that you had?
That was an overall cost of the NI economy in relation to things, so it encompasses all aspects.
And how was that arrived at?
Well, the Department of Health led in relation to that social cost study. In that respect, now I haven't the full details in relation to how that figure was compiled, but that's a publication back in 2010 in that respect, in relation to figures that related to 2008-9, I believe, in relation to the study in that regard. But we certainly can get the committee the information in relation to how that study would provide.
In relation to the fire service, 280 million, how come that's so high, or for the fire and police services? What way does that break down? How is it so high?
We'll come back to the committee in relation to compiling, in relation to how that affected the system and what procedure was undertaken to cost it accordingly.
Okay, Chair.
Danny?
Thanks, Chairman. Thank you and welcome. Thanks for your presentation. A couple of points, just on the back of what the Chairman has said. I think there's a fairly compelling case to move to explore more positively some of the experiences that certainly we've seen it in both Brooklyn and in Glasgow, and that the Minister himself saw 3 years ago. And it is slightly bizarre that almost no action has been taken. Can I ask, where do we believe now the drug hotspots are in Northern Ireland? Superintendent Hannah, to answer that. And in terms of alcohol abuse, it seems to me to be a slightly more difficult problem to identify, if you like, hotspots. It seems to be more widespread, would be my view, that the general community issue spread across the entire region as to abuse of alcohol. But I do think, what measures are what measures are the department seeking to identify how they can close down and narrow down areas whereby, in conjunction with health and social services, we can address some of these problems?
If I address the question in relation to drugs, significant areas, I mean, obviously where there's high level of population would, lead to heightened levels of drug misuse, and clearly, sort of Belfast and Derry and Ballymena, for example, always registered. But outside of that, there's the areas of concern, would include Portadown, for example, as well. So the spread is across Northern Ireland, and where you have the biggest concentration of population, you will always have the biggest concentration of drugs misuse. Don't know if that answers your question. Leading
on from that, Chair, through you, what's the Are there concerns about cross-border elements to this and criminal gangs operating unfortunately successfully?
Yeah, very much so, but not only cross-border, across Europe. We work in partnership with the Garda Síochána on a regular, if not daily basis, in relation to organised crime gang across Northern Ireland into the Republic of Ireland. And we're linked in through the NCA across to Europe and beyond in relation to importation. We've had significant success around that in relation to this year. There was £1 million worth of cannabis linked to a European organised crime gang that was linked in through Italy into the UK and Northern Ireland. And again, you know, there was links then also into the Republic of Ireland as well. So we are connected up, we're joined in with the other law enforcement agencies, and we're in regular contact on sharing of intelligence and information, developing action and joint working against these organised crime gangs.
And what's the, sorry again through you, Chair, what's the success rate in terms of charges and convictions?
Well, in relation to organised crime gangs in Northern Ireland, we have 139, 88 of which would be directly, purely focused on drugs. We have a policing plan target of 5% increase in our performance against disruption, frustration, dismantlement, but currently we're sitting at 17% improvement in that, so our success is very good. This year our drugs arrests are up, our drugs outcomes are up as well against policing plan targets, and the drug seizures were already on a par where we were last year, so we anticipate that by the end of the year we'll have reached the policing plan target there in relation to drug seizures as well.
One final point just on the on drug seizures, and again there's correlation, I think, between some drug seizures and other aspects of seizures in terms of illegal fuel. We very often find the plants and they've disabled and disused plants, or we find a quantity of drugs, but we rarely find the individuals behind them, behind either, to put them behind bars where they should be.
Sorry, in relation to drugs?
Yes.
No. When we're making seizures, predominantly we're making arrests
and catching people.
Oh, absolutely.
And are those the people? I mean, again, it strikes me that many of the drug dealers who are operating at a street level are not the big guys. They're in the vast majority of cases, they would be people who themselves are addicted to substances, and they're either paying off a drug debt or selling drugs in order to feed their own habit. How many of your drugs arrests do you? It's hard to tell, but how many are at that level compared to people who probably don't abuse drugs because they're making so much money out of it? I mean, there's a difference between a drug dealer who's selling to feed their own habit and a drug dealer who is running a criminal enterprise. Where's the breakdown in terms of the drugs arrests that the police are making?
I suppose if you consider the 139 organised crime gangs would be what we would consider the higher end stuff. It's the international importation across Europe, Republic of Ireland ourselves, and so that 70% increase in performance is linked directly at those individuals, and that creates an opportunity obviously to go further in relation to assets recovery and through our economic crime. Obviously there would be, if you consider then the street level drugs dealers, and then you consider the most recent operation, as we say, in South Belfast and the heroin issue, most of those were actually a mix of locals and foreign nationals who were potentially imported from the south, just to specifically do those small deals. So we have, there is that balance between local and non-local sort of residents involved in this, but they are more low-level ones. So we are arresting at both ends of the market.
Just one quick
that's great.
point, Chairman. Is there still linkage between criminal gangs and paramilitary organisations?
Certainly with all of our investigations, there is always going to be a potential for crossover in that environment.
So the answer is yes.
Yes. Well, I would. My assessment is that there is certainly yes. In some organised, there are some organised crime gangs that have that are past, present, or current linkages to what we know as paramilitary activity, the past.
I wonder, could Mr McCourt perhaps address the first aspect of the question as to the lack of progress from the department on what the committee has seen as good practice?
good practice in relation to?
Places like Brooklyn and Glasgow.
Well, I've already commented in terms of the problem-solving approach that the department is waiting for the outcome of the OECD report in relation to look at it in the context of what the OECD study. But we're also looking in terms of the wider domestic violence front in relation to DC and how we can expand and look at problem-solving approaches in relation to that, and particularly using the Derry model, and that's something that the department is considering at the moment.
Although again, the Londonderry court has been talked about a lot by the department in the last year as a problem-solving court. Up until that point, nobody'd really heard much about it. It was sort of operating on the initiative of the judge there, who decided to take a different approach. I think it's convenient enough that the department are now pushing it a little bit. No?
Chair, with respect, the Judge McElholm's court listing arrangement is not a problem-solving court. It's just a method in relation to listing domestic violence cases to make sure that in terms of support for the victim, that the services are there on the day, as opposed to a proper problem-solving court.
No, you're absolutely right. I don't disagree with you. All I'm saying is it's moving in that direction in terms of the work that he's doing with Women's Aid and having people in video links from outside of the building and things like that. It's moving towards a problem-solving court. You're absolutely right. It's not in the model of America. But over the last year, department officials have said to us that is an example of a problem-solving court. And the Minister seems to be suggesting that too. That's the only observation I'm making, that it seems to have correlated to some of the work that the committee are doing and being used as an example. Alban?
Thank you very much, Chair, and thank you for your presentation today. Just in relation to drugs, I mean, my own impression is that the use of hard drugs, heroin, cocaine, are regarded as a hard drug. Is that fair enough? I don't think that we've as big a problem as other jurisdictions in these islands, and I think you would agree with that. But nonetheless, there is a problem there, and it seems to be a growing problem from the information you've presented to us, the PSNI. I mean, drug seizure incidents are up by quite a significant 1,500 from 2009 to 2014. That's a very significant increase. We don't know the figures for last year, but I'm sure they reflect that type of increase. So that's a significant development. And then in relation to drug arrests, we're looking at a figure, an increase of about 600 from 2009 to 2014. Again, a very significant number. I assume that is evidence for the fact that either the PSNI are much more efficient in catching people, or that there is a growing problem. What would you say to that, Mr. Hanna?
I would like to take your first option.
Yeah.
No, but I accept no, absolutely. Culturally, drugs over the last number of decades have become much more accessible, and culturally it is within certainly younger generations much more acceptable to be used by young people. So that cultural shift has created the demand, and these organised crime gangs have to fill that demand.
Yeah.
Certainly we as an organisation and with our criminal justice partners have all collectively invested significant efforts and finances to try and resolve that issue and to sort of minimise the supply and prevent people from becoming involved with drugs.
Could I just endorse what Mr. Kennedy has just said and what the Chair has repeatedly said, that there does seem to be a lack of leadership coming from the Department in relation to trying to create some innovative ways within the criminal justice system in relation to trying to deal with persistent problems of either drug abuse or indeed alcohol abuse, because I think in our jurisdiction here, alcohol abuse is probably a worse problem than, in fact, drug abuse. And then, of course, you've got collateral problems such as domestic violence, which are not unrelated to either drug abuse or alcohol abuse. But there doesn't seem to be an innovative approach in a la Glasgow or Brooklyn where, in fact, you see the justice system associating itself very closely and working very closely in cooperation and integrating its efforts with the health service and with the social services. Can we see progress in relation to that in the near future, or is that just something that we'll keep talking about in this committee for the next mandate? I won't be talking about it, incidentally, but others will be. The chair certainly be talking about it if he's chair of this committee. But it would be a waste of our time if there wasn't some real progress made in relation to an innovative approach. And I know it's terribly difficult, but we do have to try and produce some integrated approach to dealing with these problems.
Maybe if I can respond to that. I think there has been significant improvement in terms of how health and justice work together around a number of common problems such as addiction, alcohol, substance misuse and mental health. I think over the year what we've seen through the NSD is the PHA work collaboratively with probation and other justice parts of the justice family. And just to give you an example of this, through the NSD, the PHA have worked with the probation board to the extent now that they have trained every member, every frontline probation officer has now been trained in the common assessment of the audit tool, which is a screening assessment tool. And also has trained all of our probation frontline staff in a range of brief interventions. And those services have now, and also, I suppose, linked to that are individuals that are on supervision to probation being able to access appropriate health provision through the community addiction teams, through the community and voluntary groups and through commissioned services by the PHA. And I think that's a significant advancement in how health and justice work together. I think what we're talking about in relation to the problem-solving courts, I think it's what should be looked at in terms of, being creative, being innovative in terms of how we, first of all, address the problem and look at how all of the agencies, because I think, as we said earlier, not one agency is going to crack this on their own. It has to be a joined-up approach, and that connectivity cannot be broken through any of those agencies. And I think, the fact that we have seen significant collaborative work between health and justice through the PHA and the commissioning services, that there are direct pathways of referrals for individuals within probation to access appropriate treatment services that are now consistent right across the province. I think that's a significant advancement over the last year. And I think how we work with the prison service, police and other, the justice family, in that connection and the journey through. They're all one individual passing through the same justice system. But also within health, they're the same people. Health and justice have the same people. And I think the problem-solving courts, as the Chair has spoken about and has clearly researched, is a great initiative. And I think, you will know yourself, the statistics in terms of reduction reoffending range from anything from 13% in Glasgow to 29% in the States. And that's significant. If you look at the gravity of the problem, if you look at the fact that we have 74% of individuals that are on probation present with an alcohol or drug problem, that is 3/4 of the people in the community on a supervision order. So I agree.
Okay, thanks, Chair.
Thanks, Stuart.
Chair, largely the question that all asked has answered everything for me. In terms of the direct pathways which probation staff are using, are there choke points in that? Do they face the point where health says we don't have the resource to deal with this person, or we can't get an appointment? Or in the reverse, are there court procedures which stop people from getting to the health stage?
No, not necessarily, because we have approximately 23% of the individuals that we supervise on probation would have a court direction that they engage with an appropriate treatment programme. the initiative through health, through the PHA, has actually opened up that avenue of opportunities to be able to give people appropriate access. That, you know, we all know from the evidence, if you treat somebody in the right place at the right time by the right people, you're more likely to succeed in terms of reducing the level of risk, but also enhancing that opportunity of rehabilitation. So you're able, through those arrangements and through the direct pathways, we are able to refer to the commissioned groups in the community, which then in turn can refer to the community addiction team. So the path starts and continues, and hopefully is not broken. We haven't seen it to break yet.
And how quick is it to get to step one? Because that seems to me the whole key of the problem-solving course is that you get to step one, you get to meet the person, you get to sit down, you get to the first step treatment stage on the day, as soon as you've gone through the doors of the court.
Yeah.
How quickly is that happening here?
Well, in terms of probation, they will be assessed. If you're going before the court, you will be assessed for a pre-sentence report. Your level of risk, your level of dependence and problem area with drugs and alcohol will be assessed at that level. So we will make recommendations to the court in terms of licence or conditions of an order. At that point, once we will get the order and a condition is part of that order, we will straight away, because they become the responsibility of our supervision, we will straight away, as part of a case management plan and an action plan, make those referrals. But the first step is that the probation board, having been trained, and also with the brief interventions that we are delivering as part of the Tier 1 approach, will start straight away. You know, there are obviously, you know, blockages in every system, but I think, you know, this is an illustrative example of how health and justice in a particularly concerning area such as addiction has worked well together. Now, we're currently evaluating that, but what we know and what the research would tell us is that, you know, 1 in 8 people that receive brief interventions, you know, significantly reduce their alcohol intake. So the start is positive, and I think if the journey completes itself, hopefully we will have very good outcomes.
One of the other key components of all of this would be having a judiciary who, well, first of all, identifying the judges who are willing to do this kind of work, because it's not going to be suitable for everyone in terms of a problem-solving model, and ensuring they have the expertise. Even again, where these courts work best is where the judge has the expertise in addiction issues, understands the impact it has in the brain and how substance abuse works, and ways in which people who appear in front of them are able to mask it at times as well. And that's a key component of it as well. Alex?
Thank you, Chair. The 88 drug gangs or organisations, everyone be aware of the increased attention in relation to crime families, drug gangs in Dublin. Are any of the 88 in the north, are they, how are they connected? I don't want you now to stray into anything that's operational, but in high-level terms, what are the nature of the contacts, and are any of the 88 in the north satellites of the crime families in Dublin rather than independent standalone organisations? Can you give us an indication on that?
I would say those independent, standalone organised crime gangs who reach out to other crime gangs, whether it be in the UK or Europe or in the Republic of Ireland. So, and those are continuously moving patterns of behaviour depending on what their needs are, whether it be supply of quantity or transport, etc. So for them it's a business, and that's the way they look at it.
And given that there's shifting patterns, is the relationships more with the southern criminal organisations than with Britain or Europe, or is it more variable than that?
I think it's equal measures between UK and the Republic.
The second question is that I fully endorse the comments I've made in respect to problem-solving courts and problem-solving generally as really one of the primary functions of all government departments and across government departments. But I'm picking up certainly, for the first time in a while, public concern that people getting arrested or too easily getting out on bail, and that on the far side of conviction, the penalties aren't all that they should be. And if you go into the Lower Falls at the moment, where there's a particular problem with local hoods and crime gangs, that would be a pretty strong narrative at the doors. And I haven't heard that in quite a while. The issue of separately we'll be asking questions about what is the pattern of release and the pattern of penalties and the far side of conviction, but it is very strongly felt, and that might only be a perception, but there is a sense that we're in a period where people think that bail is too easy and penalties are too light, and given that includes in respect of drug-related issues, and I just want to flag that up. The other issue is, I was reassured to hear what Geraldine was saying in relation to what is joined up, because one of the measures of the next programme for government is, of course, going to be what government departments are doing arising from Stephen Agnew's private members legislation, where there's now a statutory duty falling on departments when it comes to children's services, to demonstrate how they are joining up and given youth offending and so on and so forth, that's now a legal obligation as well as an operational intervention. And my final question is, can you give some sense of the relationship now between the PSNI and the NCA, given that they are now fully functioning in the north, and how is that relationship developing, given the need to have a crime agency that delivers for us as well as the local agencies?
Well, certainly in relation to the NCA over the past year, I personally and my team have met with them on a regular basis, monthly minimum, if not more regular than that, depending on the operational needs. And we work jointly on a number of operations, and they support us on other operations, specifically linking us through Europe and Interpol, etc. So we have found them very beneficial in that respect, not just specifically in relation to drugs, but in other organised criminality. They've been very supportive in relation to some of the cyber stuff as well. So it's been very productive for this first year. We've found a benefit, certainly.
And do you find any impediments in terms of the relationship with the NCA? Are they the big brother, or is it a cooperative relationship?
No, it's very much a cooperative relationship.
Okay, thanks. Sammy?
Thank you, Chair. First of all, could I apologise? I had to nip out there, and forgive me if I maybe cover ground that you've already covered. Brian, you'd mentioned about some of the problems with heroin use. I think it was in South Belfast. I'd mentioned at one of our committee meetings recently, we had a major problem with heroin in East Belfast for the first time, and we found over 100 heroin needles down at Titanic Belfast. And it was innocent because I think Geraldine talked about this, agencies working together. I mean, that was a good example of agencies working together, coordinated by the PSNI, the local council, but also working with local people down at bottom Newton Ards there. We often always had a good relationship with the PSNI, but that really helped to improve those relations. But it was certainly, there was a sense, having spoken to some of the local people who actually joined the queue when people were queuing up to get the heroin, to find out who was involved. They were saying they were Russians, in a sense, definitely an organised crime gang. And I know there was question in terms of paramilitary involvement a bit in some of the drug dealing, but it was certainly, to my knowledge, there was no paramilitary involvement in this case in terms of heroin. Is that the case, that in terms of heroin it tends to be international gangs in Northern Ireland rather than the local paramilitaries?
Well, in relation to that specific job, I have heard no comment in relation to, or no mention of any paramilitary links to it. The information I've been briefed on is that it was certainly Russian-speaking and also local organised crime gangs were involved, so you have a mix of both.
A mix of both, yeah. And in terms of paramilitaries, and you alluded to this, And I think what you were saying, if correct me if I'm wrong, it tends to be people who are maybe members of a paramilitary rather than the main organisations. Would that be right to describe that?
I couldn't be that specific at this time, to be honest with you. No, couldn't be that specific at all.
Thank you. Thank you.
Okay. Edwin?
Thank you, and next one I apologise for not being here for the presentation. Could I ask the Superintendent in the first instance, what's a typical weekend like in the early hours of the morning for one of your officers?
What, one of the
in the city centre, Belfast city centre, what's it like on a Friday or Saturday night for one of your officers in the small hours in the morning?
Okay, and are you trying?
In relation to the alcohol, you know, and the sorts of situations that they have to deal with.
Well, I manage reactive and organised crime, which is the detectives who
investigating drugs.
Well, it's drugs and organised crime, but we also have responsibility for the investigations of vulnerable burglaries, kidnaps, attempted murders, etc. So we're very broad spectrum. So we're less less likely to be on the uniform in the streets as such, if that's what you're referring to, sir.
Yeah, it's really I was trying to get a feel for the PSNI officer who's out on the ground on the beat on a Friday, Saturday night, whenever people are fueled in drugs and alcohol.
Yeah. I mean, I have to confess, you know, as a chief superintendent, it's been a while since I've been in crime department. You know, so I can give you my experience as a sergeant in Donegal Pass and Bradley Place, or as an inspector in North Belfast, and you know, but we are, you know, we're going back, but it isn't going to change that significantly. I mean, the officers are busy. The alcohol issues, you know, you have that broad mix of individuals who have consumed alcohol, and there will be the majority of people will be in good spirits. But there will be difficulties caused by people who are getting embroiled in disorder, conflict, and create difficulties for the officers, and subsequently there's results in arrests and individuals charged, etc. It can be very challenging for the officers, and that they can be running from one incident to another, needing to require to support each other. But again, equally, the culture of alcohol over the last, you know, number of years has changed a bit as well, and it, you know, significantly, and people are more. The culture seems to be consuming alcohol in a house, you know, before they go out. So that impacts on sort of when, you know, the escalation disorder could happen. It could go on to the early hours, as opposed to maybe happening at 1 o'clock, 2 o'clock, where with traditional sort of closing up times.
They had numbers of women drinking large volumes of alcohol now than would have been in the past.
Yeah, I mean, certainly. I mean, you know, I'm no expert in this, and you know, health people could probably advise us better. But certainly, that seems to be the suggestion. You know, my reading on it. Yeah.
I noticed that in the briefing pack there that 43% of violent attacks are taken by people who have alcohol in their system. So clearly, you don't need alcohol to be a thug, but it helps. And you know, there is a lot of attacks which are fueled by alcohol as a consequence.
Certainly, alcohol is a contributing factor, seen as a contributing factor in relation to, as a, you know, a significant percentage of domestic or violent crime.
There's also a thing there just with your stuff, Jason. I believe there's around 140 drugs gangs across Northern Ireland. Must be big business.
Absolutely.
140 is a lot of gangs to feed the mouths of. You know, if a gang's half a dozen people, there's potentially 700 or 800 people out there, you know, directly involved in those gangs, perhaps more.
Yeah, I mean,
they're living off illegal drugs.
Yeah, I mean, if you take it, the last week in January, there we had a seizure in Dargan Road there in Belfast of £1 million worth of cannabis in one container, and 2 arrests. But in the same week, across the province, with 3 separate cannabis factories, you know, each over £100,000 worth of cannabis. So there's significant money in drugs.
And in terms of it, then, a lot of the people who, you know, are arrested, they end up in prison. That's directed to Mr. Davis. Do you clean them up when you're in prison, or do they come out with do you clean them up when they're in prison, or do they come out? You know, the numbers of people who get into prison with the drugs habit, is that being reduced while they're in prison? In fact, are people coming out with a greater drugs habit having been in prison?
I think the chairman has made reference to some reports from the Criminal Justice Inspectorate in terms of their most recent inspection of Maghaberry. I put it this way: I know of no time when any prisoner has ever come forward seeking help that help's been turned away. Everything within the prison is designed to reinforce a drug-free lifestyle. We inherit a problem. Geraldine talks about numbers in the region of 74–75% of the individuals that probation would deal with. Prisons, it would be the same, potentially higher. Prisoners have complex needs. I know Mr. Poots was talking about the experience of an officer in the police and patrolling the streets of Belfast late at night. An officer in the landing faces as the same, if not greater, difficulties in terms of the complex needs that a prisoner presents, yet those officers respond day and daily. There are people alive in prisons and people alive in Northern Ireland that prison officers have saved because of their lifestyle. In terms of stopping drugs getting into prison, we have robust measures. We do our best, but we have a set of circumstances where it's not a problem that we can search or secure a way out of. We have to reduce the demand, we have to educate, and we have to promote lifestyle change. That's why when Geraldine was talking about the continuum of custody and contact with criminal justice, it happens pre, during and post. Every prisoner going out on home leave will be subject to drugs testing, potentially drug testing on return, to ensure that they continue and to maintain the lifestyle. When prisoners, and I think there's somewhere in the region of 600, 700, almost 700 prisoners with various public protection sentences within the system, they will be going out with licence conditions. Where there are drug and potentially alcohol issues in their offending, then those conditions will be put in place to both monitor and address their lifestyle issues. So in terms of do we clean them up, prisons provide opportunities for individuals to change, but we're talking individuals who can go out and then don't have to maintain that change. We do our best, we provide those opportunities, and no individual will be turned away if they're seeking help.
I appreciate that nobody's going to be turned away. What's the percentage of prescription drug use in the prison? Amongst the prisoners?
It would be in terms of
many prisoners are getting prescription drugs.
A significant number. I couldn't tell you off the top of my head. But they will be a significant number. Prescription drugs would be an area of significant concern, and probably the trading of medication would be an area of significant concern.
Yeah. Over 70–80% or something of that direction, aren't they?
Could well be so.
Yeah. And a lot of people would suggest that, particularly for prisoners who are further down the food chain, getting those drugs is very important because it is a means of them buying off other prisoners who are more senior in the prison.
Medication is treated, but I will say that in terms of that, the medical needs of individuals, where medication is prescribed, it's the South Eastern Trust are responsible for prisoner health care, and those are medications prescribed by a fully qualified GP. It's not something that's handed out.
Mm-hmm. Oh, I know, but I'm led to believe that prisoners very often will take the drug and as soon as they're out the door and back to their cell, their fingers are down the throat, vomiting that drug back up again, so it becomes that tradable item.
In some instances that's true, but I would say that is actually relatively small in terms of the overall trade in prescription medication. Mm-hmm. In terms of that, we do use supervised swallow, where certain of the most traded medications are supervised at the point of issue. We also, healthcare also do spot checks on medication within cells, and there are also secure means of storage within cells.
No, it's certainly it's a big problem, and in my view, more needs to be done in our prisons, so that the folks on probation are trying to get these people back integrated into society, in terms of training, in terms of trying to take people away from addictive habits. There needs to be more done within the prison system to prepare people for a better life when they come out, and a better contribution to society than was the case before they went into prison. Otherwise, you're just going to keep having a cycle going round and round. Any thoughts, coming to an end, Mr. Chairman, any thoughts on having facilities in the city centres for people who have been drinking heavily and have had minor injuries, as opposed to dragging them off to the emergency department, where they're hugely disruptive to individuals who are actually needing the treatment of senior medical staff, but in the midst of all, you have people who have picked up nasty gashes and wounds, but who are very, very drunk at the same time. I know they've done that in other parts of England, haven't they?
I'm not sure. I mean, I know the SOS units in Shaftesbury Square are very effective, but I'm not sure what other services are.
I think Boots provide a service, perhaps in Manchester, but in other cities, where people who can get some general treatment, and a place where perhaps they're in safety, maybe safe for themselves. But it's preventing people ending up in emergency departments, because you have dozens of people who go through emergency departments, particularly older people, and their families are supporting them. And in amongst all of that, you have these drunks who are being abusive, aggressive. Their language is appalling, and they're shouting and screaming at the top of their voices. And it's not conducive to a good healthcare system.
No, I agree. I think that that's prevention when the problem is there. I think the focus is on prevention and diversion before that problem actually gets to the stage that these people are having to present to the likes of A&E.
Well, it'd be good to see the department and PHA and others working together on developing those types of opportunities. Thank you, Chair.
Okay, thank you very much. It was a very useful session. I think the committee probably is broadly in agreement in terms of the approach that we want to see from a criminal justice end of things. I suppose it's how, and I listened to Alex's point around the public perception of these things. I think that's why the evidential base is so important. And Geraldine mentioned the reoffending rate, where we are looking at problem-solving models, but it actually keeps communities safer, it keeps victims safer, and actually it's helping offenders turn their lives around. And that's the message we need to go to the public, that this isn't some sort of either cost-saving measure, or it's not some sort of liberal progressive thing. It actually works, and that's why, and that's the message that I think we have to sell to the public. It keeps communities safer. So, look, thank you very much. It was a very useful session. And, very valuable. Thank you. Okay, members, if we move on to the less exciting element of the committee and get through these SRs, get the head down and get through them as quickly as we can. If I can move on to agenda item 6 and refer members to page 435. Just to remind the committee, on the 17th of September, we agreed that we were content with the proposal for a statutory rule under powers conferred by the Financial Provisions Act to provide for the constitution, functions, procedures and financing of the Northern Ireland Police Fund. That SR was laid by the Department on the 3rd of February and is subject to the negative resolution procedure. There have been no changes to the policy content since the SL1 was considered by the committee, and the examiners confirmed there's no issues to raise. So if we're content, then I'll put the question formally that the Committee for Justice considered statutory SR 2016/14, Northern Ireland Police Fund Regulations 2016, there was no objection for it. They agreed? Agreed. Item 7 then, page 446, just to remind the committee, on the 4th of February, we agreed that we were content with the proposal for an SR under the Proceeds of Crime Act 2002 to apply certain provisions of the Police and Criminal Evidence Order 1989, which provides safeguards and procedures in relation to the execution of search warrants issued by a court, specifically in relation to warrants that are part of a criminal investigation. The search and seizure warrants obtained in Northern Ireland under Section 352 of POCA for the purpose of confiscation investigation, a money laundering investigation, or a detained cash investigation, and the powers of procedure under those warrants. The proposed modifications under the statute rule are technical in nature, so that the provisions work in a pocket context. The ASR was laid by the Department on the 9th of February, subject to the negative resolution procedure. There have been no changes to the policy content since we last considered the issue, and the examiner has no issues to raise. So again, I'll put the question formally. The Committee for Justice considered ASR 2016/33, the Approaches to Crime Act 2002, and has no objection to the rule. Agenda item 8 then, page 458 of your folders. Just to remind the Committee, on the 10th of December, we agreed we were content with a proposal for an SR to make technical amendments to the Judicial Pensions Regulations relating to the protection of increases in guaranteed minimum pension after the abolition of contracting out in April 2016, the extension of transitional protection and portability to eligible fee-paid traditional office holders, and the removal of negligence as a basis for forfeiture and set-off pension. The SR was laid by the Department on the 26th of January, subject to the affirmative resolution procedure, and scheduled for debate in plenary on the 8th of March. The Department's advised there have been changes to the policy content since the Committee considered the proposals. The Ministry of Justice intends to make equivalent amendments to the new Judicial Pension Scheme regulations, extending transitional protection portability to eligible fee-paid judges, and for the removal of negligence as basis for forfeiture or set-off of pension. Due to slippage of this timetable, a draft of these regulations is not available. The DOJ is therefore only progressing the protection of increases to guaranteed minimum pension after the abolition of contracting out on 6th of April as part of its SR, as these regulations need to be made in this financial year. The examiners confirmed he has no issues to raise with regard to the technical aspects of the rule. So I put the question if the Committee is content that the draft SR, the Judicial Pensions Amendment Regulations Northern Ireland 2016, recommends that it be affirmed by the Assembly. Agreed. Agenda item 9 then, refer members to page 467. Just to remind the Committee, on the 28th of January we considered the results of a consultation on a review of the level of statutory bereavement damages in Northern Ireland, and we agreed that we were content with the Department's proposal to increase the level of damages in line with inflation and to adjust it every 3 years to ensure that the rate is appropriately fixed on a regular and consistent basis. The Department is now intending to make an SR which will be subject to the negative resolution procedure to increase the level of bereavement damages in Northern Ireland in line with inflation as measured by the Consumer Price Index, rounded up to the nearest £100. Based on the CPI for December 2015, this would increase the level of damages to £14,400, although the award will be set in line with the latest CPI figure, most likely that for January 2016, which will be released on the 19th of February. Are we content with the proposed SR? Does anybody want any more information?
Only just, Chair, to welcome the decision by the Justice Minister. This is a good news,
okay,
and we've been pushing for.
Yep, thank you. Agenda item 10 then, page 475. Remind the Committee on the 9th of January we noted the Department's intention to undertake a 2-week targeted consultation on the proposed police pension regulations, which will allow members of PSNI who are retiring with a protected pension age before 55 or age 55 and over to no longer be required to purchase annually from their AVC pension provider, with effect from 6th of April, the beginning of the 15-16 tax year. The Department's confirmed that no concerns have been raised in respect to the draft regulations, and is now proposing to make the statute rule, which will be subject to the negative resolution procedure, with a mind to come into operation the 1st of April. Are we content?
Two.
Yep. Agenda item 11 then, page 487. Part 3 and Schedule 2 of the Modern Slavery Act make provision for the new maritime enforcement powers, which will extend to Northern Ireland, following the passing of a legislative consent motion by the Assembly on the 8th of December 2014. The Department is required to prepare and issue a code in respect of the practice to be followed by Northern Ireland constables and enforcement officers when exercising the power of arrest when they have reasonable grounds to suspect that a slavery or human trafficking offence has been committed on the vessel that's under investigation. At the meeting on the 28th of January, we noted the draft code of practice for Northern Ireland on constables and enforcement officers that has been provided by the Department. The Department has to lay the draft code before the Assembly and bring it into operation by way of an SR. That will be subject to the negative resolution procedure. The Department has now provided the draft regulations and a copy of the draft code. Are we content with the proposed SR? Okay. Agenda item 12 is page 505 of your folders and page 280 of the tabled pack for the draft regulations. The Department is proposing to make a statutory rule under powers conferred by the Legal Aid Advice and Assistance Order 1981, which will be subject to the negative resolution procedure to introduce provisions into the Crown Court to provide remuneration where the circumstances of the case are so exceptional that the costs of presenting the case cannot properly be remunerated under the existing matrix of standard fees. Two substantive issues were raised in the consultation. The first concerned the inclusion of a provision that the Department could consult the trial judge when determining the lawyer's fees for exceptional preparation. In response, the Department has removed this provision. The second related to the proposed rates of payment. In response to the criticism of the level of remuneration for counsel by the Law Society and Bar Council, the Department has now increased the proposed rates for exceptionality. Those new rates are set out in the Department's briefing paper. The Department has indicated that whilst it's difficult to estimate how many exceptional cases may arise, they have estimated the potential cost in the region of 1 to 1.5 million per year, based on the analysis of the type of cases that have displayed the characteristics that may be considered as exceptional. Are we content with the proposed SR? Okay. Agenda 13, page 527. Just remind the committee on the 4th of February we considered the LCM outlining the provisions of the Criminal Cases Review Commission Information Bill that will extend the powers of the Criminal Case Review Commission to enable it to obtain documents from private organisations and individuals in Northern Ireland subject to judicial safeguards, and agreed that we were content to support the LCM brought forward by the Minister of Justice. A draft report in the committee's consideration of the LCM is at pages 530 to 534 of the meeting folder. I'm going to ask just if anybody has any proposed amendments to that draft report. If not, then we'll go through the draft report, just getting formal agreement from the committee. The first part, then, title, page and powers, which is set out paragraph 1. Are members content that the title, page and paragraph 1, which outlines the powers of the committee, stand part of the report?
Agreed.
Okay, and refer members to paragraphs 2 through to 8 of the report that outline the Criminal Case Review Commission Bill and the purpose of the legislation. Are members content that paragraphs 2 to 8, and which set out the Criminal Case Review Commission and the purpose of the legislation, stand part of the report? Okay, then paragraphs 9 to 15. Are members content that paragraphs 9 to 15, which outline the committee's consideration of the LCM, stand part of the report? Yep. Then paragraphs 16 to 19. Are members content that paragraphs 16 to 19, which outline the legislative consent motion, stand part of the report? Okay, paragraph 20 then. Are members content that the appendices stand part of the report?
Agreed.
Okay. And then we're happy enough for that to be published in the committee website and issued to all MLAs. Yep. Great. Agenda 14, Psychoactive Substances Act 2016. Refer to page 579 for your papers. The Department's provided a written briefing on the Act, which aims to tackle the manufacture, distribution, sale and supply of these substances across the United Kingdom, and which received Royal Assent on 20th of January. Whilst a number of the general provisions come into force following the Royal Assent, the remaining provision of the Act will be commenced across England and Wales, Scotland and Northern Ireland on the 6th of April. The briefing paper sets out the background of the Act, provides an overview of the provision, sets out the Department of Justice engagement with the Home Office, and outlines the preparation work being undertaken by the Justice statutory agencies prior to commencement of the main provisions. A copy of the Act and the explanatory notes are included in the meeting folder. So we're happy enough to note the information provided.
Noted.
Agenda 15 then, page 700 to 740 of the meeting folders. The Department has provided a written update on the delivery of its assistance strategy and action plan, which was launched in an oral statement to the Assembly in September 15. Aims to reduce reoffending and improve outcomes for people with contact with the criminal justice system. Of the 21 actions within the plan, 11 of these are being considered as achieved, with a further 10 in progress and 3 being moved to 2017 to allow for further engagement and ensure compatibility with other work streams. The Department has provided a synopsis of progress against each individual action in the plan and indicated it will continue to engage with the Assistance Working Group to consider progress and future development. The Reducing Offending Directorate will also continue to monitor progress on the action plan, and a further update will be provided to the committee in the new mandate. Are we happy enough to note that update? Okay, then move on to correspondence. Agenda item 16. There are 13 items of correspondence from pages 743 through to 863 of the meeting folder. If I can just mention a couple of them, or a few of them. Item 3 at page 754 is an invitation for the Minister to attend an event on prison reform held at Highbank Wood on Wednesday the 2nd of March at 10:30 a.m. Independent members of the Prison Review Oversight Group referred to this event during the oral briefing that we had back on the 4th of February. So if anybody wants to attend that, just let the committee staff know and we'll make arrangements. Item 4 is invitation for the Minister to the 2016 Justice and the Community Awards ceremony, which is taking place on Wednesday the 2nd of March at 6 p.m. here in Parliament Building. So again, if anybody wants to go along to that, please let the committee staff know. Item 11, page 805, is a copy of the Jenny report, a follow-up review of the management of life and intermediate sentence prisoners in Northern Ireland. Follow-up review found that one of the 3 strategic recommendations had been achieved, and of the operational recommendations, 4 have been achieved, 6 have been partially achieved, and 1 wasn't achieved. So that's really just for noting, unless anyone wants any further information. If I can go to the table pack, then item 1, page 292, is correspondence from the Committee for FMDFM, seeking the views of the Committee on a legislative consent motion in relation to the Northern Ireland Stormont Agreement Implementation Plan Bill. That bill gives effect to a number of commitments contained in the Fresh Start document, one of which may be of interest to this committee, relating to the power of the First Minister and Deputy First Minister acting jointly to nominate 2 members of the Independent Reporting Commission in clause 1.4. So if members are content, we'll request the views of the Department of Justice on this to assist consideration, and we'll determine what we do after that. Members happy enough with that approach? Any other comments on any other item of correspondence? If not, then agenda item 17, Chairman's business. Don't have anything to raise. Any members anything to raise under IOB? Sammy.
Chairman, as you know, we have David Newberger coming over. He made a very interesting ruling today in terms of the joint enterprise law, which has been, well, that was wrongly interpreted for 30 years. It's had major implications for us all. Well, for Red Cross United Kingdom. Just want to get some information on that, because this is a major change in law.
Okay. Yeah, we'll try to get some information on that.
We'll also ask David when he comes as well. Then.
I was going to say it's a good dinner conversation for members when we have them there. I did mention at the start, just to make sure that members let the committee staff know that you intend to be at the full day, so from the Law Society through to the dinner and the event, just to make sure that we have all bases covered. So if members just let the committee staff know that they're going to be in attendance that day. I think it is a good event, a nice one to finish the mandate off with. So as I said earlier, please do make an effort to be there.
Chair, I'm just surprised that Sammy has to ask for information. I thought he just, was on the telephone to
Davey.
My mate Dave.
Call me Dave.
Sammy is courteous, so that's why he's not there.
Just for other people,
earlier crew.
I spent 3 days with Lord Newberg, and I must say, for a very interesting man. I'm over in Isle of Man, so looking forward to him coming over.
Excellent. Okay, thank you.
Right, Chair.
Yep.
Can we go back to the LCM just for a moment? The previous item. I think the committee should ask for a briefing, because we're facing a situation where at the very end of this mandate we're going to be asked to agree an LCM. It has come up at very short notice because the legislation hasn't been tabled at London yet. I'm not aware of any committee getting a full briefing in relation to the legislation, and I think that should be rectified. But the particular clauses in relation to the creation of the International Reporting Commission are very extensive, and I'd be particularly interested to hear the view of the Justice Minister, given that that organisation will have responsibilities in respect to criminality and paramilitarism. The view of the Justice Minister that the Justice Minister doesn't have the power to nominate anybody to the IRC, and that the nominations from the North fall to FM and DFM. It seems to me a bit of an incongruous place that an organisation that's going to deal with issues of criminality and paramilitarism, the Justice Minister doesn't have any powers of appointment, or what his role may or may not be in relation to the appointment of people to that organisation. So I do think that later on there should be more respect shown to the committees of the Chamber about the contents generally and specifically in relation to the LCM.
Look, we've agreed to write to the department, get a response from the department. Our only difficulty is that the OFM-DFM committee haven't given us an awful lot of time to respond to them, which I suppose does make it more difficult for us to arrange anything. But what we'll do is, if we get that response quickly from the Minister, it might help members in terms of our consideration of the matter. So I'm sure that that message will be passed on to the department when we ask them for comment, and that might assist us somewhat. Okay? Okay, any other business? No? Okay, date, time, place, next meeting then, 25th of February, 2 p.m. in this room. So thank you all.